before
No,
the
it's not my
JSC?
first. It's not my first. I've been here before.
So you know the drill.
I think so, yes.
Okay, no, it will be fine. You have 4 law degrees.
Yes.
A BProc you obtained at the University of is it Teflop?
Limpopo, University of Limpopo.
University of Limpopo.
Yes.
All right. Then an LLB from Pretoria,
Yes.
University of Pretoria.
University of Pretoria, yes.
And
Yes.
then these 2 master's degrees.
Yes.
One in human rights and constitutional practice,
Yes.
and the other one in labor law.
In labor law, University of South Africa, yes.
The one in labor law from UNISA,
From UNISA, yes.
and the other one from the University of Pretoria.
University of Pretoria, yes.
And those, the last 2 degrees you obtained while you were working you were practicing as an attorney already.
Yes, I think one was an attorney, the other one was, I was an advocate already.
All right.
The other one was 2018.
You started out as a teacher,
Yeah, as a private teacher, that's where I started.
but just for a short while.
For 6 months. Yeah.
Why did you leave?
Sorry?
Why did you leave teaching?
Yeah, no, I wasn't a qualified teacher. Just there, I went to collect the result, and the principal asked me to assist, and I just stayed there for 6 months.
All right. Which subjects were you teaching in that 6 months?
I was teaching English.
All right. Then you joined the Department of Justice
Yes.
in Limpopo
In Limpopo.
as an administrative clerk.
Clerk, yes.
Clerking both in the civil and criminal courts.
Civil and criminal court. I was the
How
clerk
long
there.
were you in that position?
I started there from 1981, I think 1980 to 85 when I left to the university. Yeah.
But then you became a prosecutor in that period.
It was an ad hoc basis. It wasn't like you were asked.
It was not a formal
on the day.
appointment.
Yes, for the appointment for a day. Yes.
But you did the work of a prosecutor.
Yes, I did.
All right.
Yeah.
Then you did your articles in 1989 and joined the Lawyers for Human Rights directly after you completed your articles.
Yes.
What did you do in that organization?
I was a director, a deputy director litigation, also coordinator for the program there. Yes, that's mainly what I did.
Then you started your own firm.
We were 3. Yes, we started our own firm of 3.
With 2 others.
With 2 others. Yeah.
And how long did you remain in that practice?
We started, I think, 1993 or so, until I left 2006 and I joined the bar.
And you indicate that attorney's firm did all sorts of work across the board,
Yes.
civil and criminal.
Yes, we started like doing general things, but mainly it was a criminal matter. It was a criminal firm, and then we did other things as well.
Then you joined the bar in 2008.
That's when I was admitted as a member, but I resigned. 2007, I did pupillage. In 2008, I completed my pupillage, and then I joined as a member of the Bar Pretoria Bar.
And you've been practicing as an advocate since?
Since then, yes.
Okay. What kind of practice are you running?
Well, I started as civil mostly, but mostly I also do labor, and also traditional leadership. But also I do mostly. Yeah.
You also worked part-time as a CCMA commissioner?
Yes, I did a course there, passed, and then I was part-time commissioner at the CCMA, and even bargaining councils as well.
Okay, for about 6 years?
Yeah.
Okay. Just tell me about your acting stints in the High Court. When did those start, and for how long have you acted in the High Court?
Yeah, I started acting from 2019. Last year I had done 65 weeks. Yeah, and then I added 10. They say it must be 75 weeks, but I see I wrote 68 weeks. So I've been there. I also acted in Gauteng, but mostly in Limpopo.
All right. How many weeks did you do in Gauteng?
Gauteng, I think I did 1 or 2 terms in Gauteng.
Okay. And you've had occasion to write judgments during this acting stance.
Yes, I wrote judgments, yes.
In which areas of the law?
Different areas of the law. The last one that I did, I think I did on traditional leadership, but the last judgment that I see is attached here with the documents was about the traditional leadership court. Yeah.
Do you have any reported judgments?
No, I don't have a
Not
reported
yet.
one. Yes, there's only in Salfi, but I understand those are not reported judgments.
Okay. But you've sat in all the courts?
Yes, I said in all cases, criminal, civil, I did everything.
Have you conducted trials? Civil and
Conducted
criminal?
trial, conducted civil trial, conducted even criminal trials.
Okay. How many criminal?
Criminals that I remember now, I think there are 2 that I remember now. But I did.
To completion?
Yes, I completed them. I did them. One I did in Polokwane, the other one I did in Thohoyandou,
Okay.
the full trial.
Okay. Do you have any reserved judgments?
No, I don't have reserved judgment.
Any parted matters still
No.
requiring you to go back?
No, I don't have parted matter. I don't have reserved judgments.
All right. No, thank you, Advocate. JP Patudi? Oh, and I'm sorry, I forgot to welcome you. It's been a long 1.5 weeks.
No, thank you.
Welcome, JP. Do you have any questions for the candidate?
Yes, thank you, Chief Justice. Good morning, Advocate Ledova.
Good morning, Judge President.
Yes, the Honorable CJ has already inquired from you as to the number of weeks
Yeah.
for which you have acted as a judge,
Yeah.
in both Gauteng and Limpopo.
Limpopo, yeah.
Yes. I know that in your questionnaire you've initially mentioned 68,
Yeah.
but did you find occasion to act thereafter to increase the tally?
Yes, yes, well, 68, yes. Even now, I'm on pro bono basis, but the last time I was also in pro bono, even now, I've been appointed on pro bono basis.
That's until the end of
The
the
end of
fourth
this
term.
It's the fourth term, yes.
All right. So all in all, you have, as we speak, about 75 weeks, as you say.
Yes, that's 75 weeks, yes.
All right.
Yeah.
In that period, were you able to sit and preside over agent motion court
Yes, I did agent court as
And-
well.
and also unopposed motions,
Also
opposed
on opposed
motions?
Yes, also on opposed motion, I did.
All right. What about criminal appeals?
I sat on criminal appeals as well.
Did you find time to write or opportunity to produce a judgment or
Yes.
judgments?
Yes, one of them is attached here to the documents. I also.
Yes,
write
in
the
your
judgment
questions.
on it. Yes.
All right. And what about civil appeals matters?
Civil appeals as well. I sit on civil appeals.
Yeah.
Also the judgment, one of the judgment that I wrote here, I wrote for the full court.
Yes.
Yeah.
And I also see that you've mentioned in quite a number of judgments that you reproduced.
Yes.
And the question was whether was any one of them upset by the appeal court.
Yes,
And you
that's
mentioned only one out of those that you have mentioned.
Yes.
And there's a chair on top, there's one of, which was confirmed by, is it Medford?
Mary Fawn
Yes.
was confirmed at the SCA and also at the Constitutional Court.
So it was confirmed by the Constitutional, which means you were correct from the beginning
Yes.
in your judgment.
They said I'm
Acute.
correct. Yes, they said I'm correct.
Okay.
Yes.
Now, at page 21 of your questionnaire,
21.
2.1, I think it's under section 3 there, paragraph 2 thereof.
21. Yeah.
Have you arrived at that page?
Yes.
Yes. You mentioned that should you be appointed,
Yes.
you'd consider relinquishing your shareholding
Yes.
in both companies where you serve as shareholder
Yes.
and director, Gemini Holdings Pty Limited, and is that Chorwana
Yeah.
Properties,
Yes.
which is a close corporation.
Yes. Close cooperation. Yeah.
Yes. I note that you say that if I'm appointed to the bench, I propose to resign
Yeah. Well.
from those positions.
Yes.
But,
Okay.
yeah, the question is, what procedure would you follow to effect your resignations? I know many people tend to just issue letters and say, I've resigned from either directorships or from close corporations where they've got the members' interest.
Yes.
So what procedure would you follow in order to effect the necessary resignation within the ambit of company law?
No, I'll submit my resignation with the company registration office.
Yes,
Secret.
that's the registrar.
That's the registrar. We'll just
Okay,
say
so
that.
there is a form there. Yeah.
There's a
Are you
form that
aware?
you must-
The letter is not enough.
Yes.
Okay. Now, during your interview by this honorable commission in October of 2023,
Yes.
an issue was raised about a dispute you have had with the Legal Practice Council.
Yes.
And I note that you say the issue has now been resolved
Yes.
by way of settlement.
Yes.
Would you confirm that?
Yes, I confirm that. I attach a letter from the complainant said we have resolved this, and then she undertook to withdraw a complaint, and later I was shown a letter that she sent to the council, LPC, to say, I'm withdrawing this. And later, and I was shown this letter in May, and then in June, I asked for a letter of good standing, and then I was told there's nothing in my file.
Okay. Thank you. I have no further questions to the candidate.
Thank you, Judge President. Premier Ramatuba, can you hear me? Premier, are you on the line?
GNU.
Is she still connected? Yes, she is. I'm just going to check if they've put the speaker. Okay. All right, we'll have to wait. You see, that's the problem. They want their names to be in these proceedings, but they don't have time for it. I just don't understand that. I just don't understand it.
Yeah, that's it. Copy here, that's fine. But she's the supervisor of the unit that processes these things.
Is she connected? Is that you? Is that you, Premier?
Good morning.
Good morning.
Am I on, Chief Justice?
Yes, although there's an echo.
I think the challenge is the connection on your side, because from the beginning, we have always been audible.
Oh, you were able to follow the proceedings.
I've been able to follow everything that you have been saying, and also what Judge President has indicated. What I can say is that I've been covered by our Judge President, so I don't have anything further to ask.
Thank you, Premier. Any questions for the candidate commissioners? But the sound people must please assist us. There's something wrong with that connection. Commissioner Lekhanyan?
CJ, good morning.
No,
Good morning,
and
CJ.
this sound issue has prevailed since we started here. Why is it not being solved?
Must I proceed?
Yeah, let's try.
Okay. Good morning, JP.
Good morning, Commissioner.
Good morning, Matabel.
Good morning. Good morning, Commissioner.
CJ, my question is going to be very short. It's with regard to mediation, since the candidate has completed a course on arbitration. I wanted to check, given the predominance of traditional leadership disputes in our province, do you think that mediation is an option? And if it is an option, what do you think will be the benefits towards the stability of our rural communities and enhancing the chances of sustainable development?
Commissioner, I think mediation, it will benefit us. In the first place,
Just bring the mic closer to you. We can't hear you.
Yes, mediation is a very important part of dispute resolution. Even in our course, we have section 41A that deals with mediation. But I think it's very, very important that issues like this one, where that dispute about traditional leadership, if there can be more mediation can be involved, it can resolve many problems, because sometimes coming to court itself, it doesn't solve the problems. We get a judgment, we get an order, we go back because there was no proper engagement between the parties. Most of the time, parties go back to their own positions again, and the dispute starts again. So I think mediation, it will play a very, very important part in dispute resolution insofar as the traditional leadership dispute are concerned.
All right.
Yeah, no, Matabel, I think your details are very skimpy. I want to know what will be the benefits for a province like ours. I agree with you that mediation can be an option. You answered that question in affirmative.
Yeah,
Yes. Okay, let me say it this way.
yeah,
Traditional leadership disputes have divided our communities, you know.
yeah.
So what will be the benefits if we follow mediation as an option?
Yes. Like I say, the mediation helps because we have a third party involved, a neutral party involved that assists the parties to resolve that dispute. So the benefit is you've got somebody in between you who assists you, and it gives the parties of both sides to ventilate their positions to the mediator, so that the dispute is resolved in the sense of each party having contributed his version. So, like I say, if we rely only on court decisions, without the parties having had the opportunity to say their version to an independent party, it may not assist as much as we've got a third party assisting the parties to resolve that dispute.
Okay, thank you. Commissioner,
Chair,
is the follow-up?
CJ, a follow-up.
All right.
Thank you. Good morning, CJ. Good morning, commissioners. Good morning, council.
Good morning, Commissioner.
A follow-up from what my colleague has said. There is an objection, one of the objection, of course, but the others will be taken by my other colleagues.
Yeah.
But what is incidental to what my colleague is saying is an objection by Joan Jacobs of Uber and May attorneys.
Yes.
As regards the matter which they allege you delivered a judgment on the 6th of September this year.
Yes.
And amongst other things, they say you then made a pronouncement that you do not have a that the superior courts have no discretion and jurisdiction to interfere with the judgment of a traditional court.
Yes.
The question is, was this brought to your attention, this objection?
Yeah.
And if so, what is your response to that objection? Or what was your response to that objection?
Yes, I responded to the objection, and I said it's not correct that I said the High Court should not be involved in this. What my problem was that when they approached a High Court, they wanted a declaration to declare the judgment from the traditional court a nullity. And I said, no, it can't be in that way. Even if you think that the traditional court has no jurisdiction, and you think the High Court has jurisdiction, the way to do that is to take a review and not to declare the whole judgment of the traditional as a nullity, because that was my problem. And that's how I responded to the query, to the complaint.
Thank you, CJ.
Thank you, Commissioner Nkonyane. Was your hand up, Prof? Go ahead.
Thank you very much, CJ. Good morning, Advocate.
Good morning, Chief Commissioner.
You know, I'm interested in establishing whether the judges or the would-be judges that are interested to be appointed, they are familiar with tried principles, because when one reads judgments of late, it seems to me that some of the principles that one thought were tried are not actually gotten right.
Yeah.
So this question is based on that on that premise.
Yeah.
Let's say a party before you wishes to apply for condonation.
Yes.
And you have to consider that application.
Yes.
What is not necessarily the test, because the test will be the interest of justice, but how has the courts developed the criteria that needs to be complied with for the court to be able to consider whether or not to grant the condonation? In other words, what would the person before you have to do to convince you that it is in the best interest of justice to condone whatever it is that they want to be condoned?
Okay, yeah, well, the best interest is the overall assessment at the end. But what the party needs to satisfy a judge is the reason for non-compliance. Why did not comply? Secondly, and how long did you take not to comply with it? So if you explain to the judge that I was aware of whatever court order or the date, but I did not comply because of this, and the court wants you to tell in each and every, tell the reason why, the date, why did not do this and this, you must explain fully why you did not comply with that. And then the other thing that you must convince the court is that there are prospects of success in the main. So they're not giving you a condonation just for that, and then you don't have prospect on the main. So you must convince the judge that you've got the reason not to comply, but on prospect as well. You've got prospect of success in the merits in the main.
And the issue of prejudice as well.
And the
Thank
issue of
you very
prejudice
much,
as well.
CJ.
Thank you. Commissioner Nkaito?
Advocate Ledwaba, I just want to get some clarity because there's something I don't follow with this settlement and the letters from the LPC.
Yes.
You are a member of both Limpopo and Gauteng.
Yes.
And why don't you have a letter of support from the Limpopo Legal Practice Council?
Well, I didn't ask for it, but I don't know why they didn't. They are aware that I'm a member here, but I don't know why they didn't support. I didn't ask them.
No, but I would have thought that if you are a member of two societies, you would ask for a letter from both.
No, I didn't ask them. No, I didn't. I didn't approach them for a letter. I didn't approach any of them.
Well, that's what I don't understand. You have to ask for a letter of good standing from your professional bodies.
Oh, okay. Letter of good standing. Okay, I thought the Legal Practice Council covers both of them.
No, the one you have is from Gauteng. It doesn't cover Limpopo.
Well, there is a confusion because when I moved to Limpopo, I didn't deregister myself from Gauteng. And when I asked this letter, I went to Polokwane, and Polokwane said, no, it's still registered in Gauteng. So you must go and get the letter from the Gauteng. So I went to Gauteng and got the letter. So I'm a member of Polokwane, but I'm still registered in Gauteng. Even the GCB, my GCB, I deducted from Tshwane. It's not deducted from Polokwane.
And there are also no letters from the societies themselves.
Yes, that's
Neither
right.
Limpopo nor Pretoria Society.
Yes, I thought that's what we asked before. That's why I said I didn't ask them.
Yes, well, even the law society, I mean, the legal practice, there's only one. Then when I look at this, the issue that I took with you last time
Yes.
was that you were accused of duplicating invoices.
Yes.
Now, when I look at the settlement you have attached, Annex IE, it has nothing to do with duplicating invoices.
Yeah. Okay. Let me put in this. Why there was the talk about duplication was just like this. When I submitted an account, there were issues that we discussed with them and say, okay, you can't take this one, and they took them out. And when I submitted, and they said to me, I must submit a new statement. I submitted a statement. And then that statement, the figure went up. And then the complaint was late to the council, and we were called by the investigating committee. And the investigating committee said to us, what is the issue? And I said, we differ about the figures. Because after taking the figure out, we differ about the figures. And they say, do you think you'll be able to resolve this in 30 days? And he went back, we sat down, we agreed on the figure. And that figure, after we paid that figure, so only after they paid me figure, they wrote an agreement to say, we settled that figure, that matter. And that's why this matter is proceeding, the matter that we were in dispute with, after the money has been paid.
And there's no letter here from the
LPC saying that the dispute or the complaint of duplicating invoices has been withdrawn.
No, there's no letter. But what I can tell you is that
Do you agree with that or not?
I agree with that.
Yes.
But what I can just in response to that is that after we went in April, investigating committee, then the complainant showed a letter that he gave to the council to withdraw. Then when I went in June, they gave me this letter of good standing. So that gave me comfort that there's nothing outstanding. There's no complaint that's there with the council.
No, the complaint, you see, this is the problem, Advocate Letwaba. I'm terribly sorry. If you're an advocate and there is a complaint of duplicating invoices against you,
Yes.
it doesn't matter that the complainant wishes to withdraw it, whereas I don't even see any withdrawal by the complainant of that. Because it is still up to the LPC as the custodian of good morals
Yes.
to decide whether to continue the charge against you.
Yes.
There is nothing here that shows that they have decided not to continue with the charge. There is no response from the so-called complainant that the duplication of invoices charge has been withdrawn. You've submitted a settlement agreement which seems to be about the fees that you will charge in the future, which for me really looks like there's something wrong here that you are doing.
Okay. Maybe let me get to that letter. I didn't get to that letter. What page is that letter?
The settlement agreement is page 132
132 of the...
of your application.
Yes.
Attached to your covering letter, nomination acceptance, it's Annexa E.
Yeah, let me just see where the... Number eight, that's number eight. Number 8 says that the complainant undertake to withdraw the complaint at the
Yes,
LPC.
I know.
Yes.
I don't have anything that says the complaint was withdrawn of duplicating invoices, and I don't have anything from the LPC that says the complaint against you is no longer being pursued.
Well, Commissioner, if you're not happy with the letter of good standing that was given to me in June, after this letter, well, I don't think I can take it any further. I was comforted with that letter, that good standing. That's why I asked it in June. So if the letter says to me in June that there's nothing outstanding against me, and maybe you're saying to me after June they can come back and say there's a complaint which has been withdrawn, I can't take it any further.
Well, I don't have anything from Limpopo, I don't have anything from the societies, and I don't have anything about what happened to the duplication of invoices. So I just don't understand.
Yeah.
Sorry, can I make a follow-up, Chief Justice, just on this thing of good standing? I just want to make a correction, and correct me if you know otherwise. A certificate of good standing does not mean that there's no complaint against you. All what it simply means is that we have paid the dues and you are allowed to practice. It doesn't relate to complaint.
Well,
In fact, what I'm saying, that is the purpose of the letter of good standing.
Well, if I understand that if you can look at that it says there's nothing, there's no complaint. Can we look at the letter of good standing, letter from the Law Society, from the LPC? What page is it?
Sorry, I'm saying to you.
Yes.
This is what
Oh,
I'm saying.
okay.
I'm saying as a matter of fact,
Yes.
the certificate of good standing
Yes.
does not mean that there's no complaint against you.
Oh,
It simply means you are in good standing with your subscriptions, that is payment of membership fees and all that.
Okay.
Yeah. So your answer is incorrect to Commissioner Ngubaitu to say, no, because I have a certificate, therefore that complaint I treat it as if it is not there.
Yeah. Well, I don't know. If the commission is not satisfied that the complainant has said to me, I'm going to withdraw this complaint, and then she gave me a letter that's sent to the LPC to say that I've withdrawn it. If the commission is not satisfied with that, I can't take it any further.
Commissioner Pillay?
Thank you, CJ. Good morning, Advocate Letwaba.
Good morning, Commissioner.
Perhaps I can ask you to open up the letter from the LPC. It's at page 81 of the bundle.
81.
Now, part of the difficulty.
Sorry, is it
Page
page
81, 81.
81 of which bundle now? I think
Your bundle, the bundle that's got your application in it.
this one?
Oh, you're reading your screen.
That's 81. This is 31. 31. This is 31. I'm sorry, it's 30, it's 31. My 3 looks like an 8. It's 31. It really does look like an 8.
It does.
Do you have that, Advocate Ledwaba?
Yes, I have that, yeah.
Now, the first difficulty is that this certificate comes from the Gauteng LPC.
Yes. And what's the difficulty about that?
So obviously, we don't know what's pending before the Limpopo LPC.
No, no, I've explained that I'm not a registered member in Limpopo as we stand now. That's why I got the letter from the Gauteng. When I went to them, to Limpopo, to say, give me a letter of stating, they say, no, you're not registered as a member, so go back to Gauteng.
All right. Then
Yes.
can I ask you to go to paragraph 3 of that letter?
Number 3, okay.
And I think that's what you rely on. But it's quite a specific paragraph. It says that it certifies that your name has not been removed from the roll and that you have not been suspended.
Yes.
And there are at this date no proceedings pending by the council to strike your name from the roll or to suspend you.
Yes.
So it's dealing with very serious, extreme ends of misconduct, which could result in a striking or in a suspension,
Yes.
but not dealing with what we would understand to be misconduct in the ordinary course. So there's no indication in this letter that an ordinary misconduct proceeding is not pending against you.
Yeah, well, yes, if you put it in that way, that I understand this. Like I say, if the commission not satisfied with the letter, with the agreement, and that she showed me a letter that gave to the council to say I'm withdrawing it. If she's not satisfied about that, I can't take it any further. That's what I took that as being a conclusion to say the council will not be able to proceed in a situation. A complainant said, we have settled our dispute, and I withdraw it. And this is a letter that I'm withdrawing.
You see, Advocate Ledwaba, the difficulty I have with your explanation is that the contents of the letter are plain. You just have to read the letter to understand what it certifies and what it confirms.
Yes.
And it certainly doesn't confirm that there is absolutely nothing pending against you as you are sitting here today.
But if you say, if they say, I undertake to withdraw a complaint, the only complaint I had with them related to that statement. But if that doesn't satisfy you, I can't take it any further.
Because you've got no confirmation that the complaint actually was withdrawn. We've got the undertaking that it will be withdrawn, but no confirmation that in fact it was withdrawn.
I said when I explained, I said, I went to her, and she showed me a letter that she sent to the council to say, I am withdrawing this complaint. I did not know that it would be an issue, and then I would have brought that letter. But if you say to me, she has made an undertaking to you, she has given LPC a letter withdrawing that a complaint, and it says, still the LPC has a discretion to proceed, I can't take it any further. I was satisfied with that explanation.
CJ, do you follow up on that?
Yes.
Yes. Good morning, Advocate Ledwaba.
Good morning.
The letter, I think the difficulty that we're struggling with is the settlement document that you have attached.
Yes.
It speaks to the future,
Yes.
how you would be charging for services to be rendered. So it doesn't tell us anything about the dispute, past dispute, and how it was settled. It doesn't tell us anything about that. Now, so that's the first thing. And so on the face of it, it looks like you have attached the wrong document when you speak about, because in the body of your application, you say, I attach a settlement agreement. And when one looks at this, it doesn't speak to to the complaint as resolving the complaint, the terms of the resolution. So that's the one struggle that there is. And then you keep referring to this letter. From your last interaction with Commissioner Pillay, I take it you haven't sent that letter to the JSC?
No.
You haven't?
No, no.
Are you able to do that?
The letter from...
If you are required, if you were given the
Yes.
opportunity to present it,
Yes.
would you?
If I was, okay, let me answer in this way. Because this complaint had resulted in the main matter that we're supposed to do not proceed because of fees, and then we then resolved everything, even that comes to say, even in future about this matter, let's agree how we're going to conduct this matter, because we don't want to come back and we've got problems. And then we agreed only even if the fees in relation to this matter, so that this matter proceeds without problem. Because remember, this register was taken over. It's taken over from another registrar. And she was coming to say, I'm not happy with what you were doing with the previous registrar. So going forward with this matter, let's resolve everything. So we covered everything. You can see that we covered even the traveling allowance and everything. So it was dealing with that matter so that that matter will proceed. As we speak now, we have agreed to set the matter down. But the letter, if you say to me, given an opportunity to get a letter from the complainant herself, in which she sent a withdrawal, I can get that letter from you, because she gave me that letter. I had letter. I didn't know that it was community issue. I can get that letter and present it. That letter I have.
Yes, it's really not just about the complaint having been withdrawn. As we understand, I understand it.
Yeah.
The complaint was you were overreaching. You were double invoices. That was the complaint. So when you say the matter has been settled, one expects clear terms of, well, it's accepted that you were not double billing. That's what the settlement would entail.
Yes.
Alternatively, you were double billing and you have paid back. One expects to see that when you say the matter has become settled. It's not good enough to simply say the complaint was withdrawn, because our interest is not just whether there's a complaint pending. It is also, was there merit to the complaint against you of double billing or double invoicing, and how was that finally resolved? And right now we don't have any of that.
Okay, I can explain that one. Let me give back the background of this situation. I had presented the bill, and in that bill, there were items that we agreed should not be there, and then we removed those items. And then they said to me, for their internal process, I'll need to submit a new statement. Then I submitted a statement. When I look at the statement, the figures then was more than that the figure that was there. And then I sat with the legal officer, and I said, this is a problem, because the figure now is more than the figures there. And even when he made the figure, and remember the history, when he made the figure became even more. And we couldn't agree. And that's where the problem that came and said, well, we can't agree with the figure. But when we went to the investigating committee, the investigating committee said, can you settle this matter? Because it's only about the figures that you differ. That's why they went back. And then the complainant drew up this agreement. And then on the previous account, I did not have to submit another account, because another account was now causing confusion, because then I had submitted less money. So they used that statement that I gave them to them, and they just deducted what was agreed upon, and then we read that figure. That figure is less than the figure that I given them later when I conducted the statement, and the statement that was given by the legal person, I mean the manager himself. So we had a situation where I submitted a statement, and that statement was less than what I was supposed to be paid. And because we had a figure to say, if we deduct these items, the figure should be less than this figure. And when I did the next statement, it was more than that statement. And even from the council, it was more than that. So there was a figure that was more than that was expected. But when we settled, when we came back from the investigative committee, the complainant went to the original statement and just deducted that we agreed upon, and then that was paid. So that agreement was written by the complainant herself, and it was covering all the issues, including going forward, because she was new, it was a register that was new, that she wanted new arrangements to be done. So that explains that. So this agreement, this was not written by me, but I accepted it. When I said, how much are you going to pay me? She said, we're going to pay you, we're not going to use new statements because now it's more than the figures. We're going to use the old statement, just deduct the money and pay you, and then I accepted that.
Thank you. Thank you, CJ.
Commissioner Matolo Dlebo?
Thank you, CJ. Advocate Ludo, what I just wanted clarity, the fee issue, was it done by the fee assessment of the LPC?
No, I had requested, when this started, I had requested that this be done by the fee committee. And the LPC decided, no, it's not yet a charge. You have not been charged. It must go to the investigating committee first. And this is the investigating committee that look at these three statements. The statement that are submitted with the deductions, the statement that I made, which was more than the statement that I submitted, the statement that was done by the legal manager of the council. This way were higher than the figures. And they said, but can you settle this matter? I said, I'm going to settle this, but I can settle it. So I accepted the figure that was less than the figure that I arrived at after making the recalculation, giving a new statement. Even the figure that the council itself, it was 408 or something like that. And then we went back to that figure where I had made wrong calculation that was against me. And then I accepted that.
Thank you. At least I'm clear that it went to the investigating committee. Then
Yes.
They advised you to, there was a discussion.
Yes.
Then that's what they advised you. But I just wanted to bring clarity to this issue of good standing.
Yes.
The LPC will never issue two letters. You either get a registered, if you are registered in Gauteng and Limpopo,
Yes.
but they take the place where your registered office is. They want, Limpopo and Gauteng won't give two letters. It's only one where you have registered. Thanks.
Yeah.
So you practice in both provinces, though?
Yes, as I speak now, I haven't deregistered myself from Pretoria. I'm still a member in Pretoria, but I don't have an office there in Pretoria. I'm in Limpopo. So like I say, my GCB money are still deducted by Pretoria. So when I went to Limpopo and said, can you give me a good standing? He said, no, you're not registered members here. You must go back to Gauteng. And I went to Gauteng. Indeed, Gauteng, I found out I was still a member. Then they gave me this letter.
All right. Commissioner Mangena, is yours a follow-up question?
In relation to this letter of...
Okay.
yeah.
Then ask the question so that you can settle this once
good.
and for all.
Can I proceed, CJ?
Yes.
Yeah, okay. Good morning, Advocate Ledoa.
Good morning, Commissioner.
Just clear this cobwebs for me.
Yeah.
When your complaint
Yeah.
was registered with the LPC, you
Yeah.
were notified that a complaint has been lodged against you.
Yes.
And subsequent to your engagement with the investigating officer,
Yes.
you were offered an opportunity to address whatever issues
Yes.
with the complainant.
Yes.
And since then, you have not had anything from the LPC.
I haven't had anything from the LPC.
Because my understanding is, if a complaint is withdrawn against you as a practitioner,
Yes.
the LPC, in as much as they notified you about the complaint, when it's withdrawn,
Yes.
they are obliged to write you a letter and advise you that the complaint has been withdrawn.
I'm not sure. I'm not sure there's an obligation on them. But if they received a letter withdrawal in May, and I haven't had anything from them. I thought that is the end of the matter. I accepted that is the end of the matter, because if they receive that letter, which I undertake to give to them, to the commission, and if in June then they gave me letter of intent, then it's understanding, and that complaint was still at investigation level. It was not at it not reached a decision where they said there is a misconduct against you. It was just a complaint. It was at investigations level. So if I haven't received any letter from them, I don't know if they, at the investigation level, they give you a letter to say this matter is not proceeding or not, or they give you a letter only after you have been charged for misconduct. Because as we stand now, I've never been charged for misconduct. It was still at the investigation level. That's why the committee itself said, having listened to what you say, this is a dispute that you can resolve, because it's a fee dispute. And I understand why Commissioner Glebu say, because it was a fee dispute, was it with the committee? And in my letter that I wrote to the council, I said, if the commissioners can have a look at that letter, I said to them, in my view, this is a matter that can be dealt with by the fee committee. And they said to me, the fee committee comes in only after you have been charged. Because you have not been charged, it's still at investigation level. It's done by investigation committee.
Yes, and that is how it should be, because a complaint does not necessarily translate into a misconduct.
Yes.
It becomes a misconduct once the council, through its officials, have established all elements necessary for it to constitute a misconduct.
Yes.
But here's the issue for me.
Yes.
This complaint, in which LPC was it registered?
Yes.
Was it in Gauteng LPC or Limpopo?
It was in Gauteng, and even when I received that complaint, I asked them if the commissioners look at the documents, they've got documents that, and I said, but why am I charged in Gauteng because I'm in Limpopo? They said, no, we decided to charge you in Gauteng. I didn't have a problem with that. So it was in Gauteng, I was charged in Gauteng, even though at that point I was in Polokwane.
Thank you, Advocate. Thank you, Chief Justice.
Commissioner Trollip.
Thank you, Chief Justice. I don't want to flog a dead horse, but I do want clarity, because there's some ambiguity about the answers to questions. When Commissioner Ngukai Tobi asked Advocate Ledwaba, do you practice in both provinces? He said yes.
Yeah.
He said, are you a member of both LPCs? He said yes. And he said, there's only one letter from the Gauteng LPC. Why isn't there a letter from Limpopo? He then said he didn't ask for a letter. And then Commissioner Ngukai Tobi said, and there are no letters from the societies. And he confirmed that he didn't ask the societies for any letters. But then he said, when I asked for a letter from Limpopo, they said I must get a letter of good standing from Gauteng because I'm not a member of Limpopo. Now that confuses me, because even the answer to Commissioner Mangena now, he's just said, he asked why were they charging him in Gauteng and while he was working in Limpopo, and they said because this issue arose in Gauteng. Now, I need clarity. Is he a member of the LPC of both Gauteng and Limpopo, yes or no?
Well, the LPC is here, and that's what Commissioner Matolo Dlepu, I thought, explained earlier, but she can do that again.
Well, the LPC is one,
Yes.
but we've got provincial offices. So my movement from Gauteng to Limpopo, I did not resign as a member of Pretoria Bar. So I remain a member of a Pretoria Bar. And I joined Polokwane. So I remain a member of two bars. But LPC is one. I think the question is, why do I get one letter from the province of Gauteng, not province of Gauteng? I said, I went to Gauteng province for a letter of good standing. They said, you're not a registered member here. You're still registered in Gauteng. That's why I went to Gauteng. About the request that Commissioner asked, I thought she was asking if I've approached my societies about the letters, and I said, no, I did not approach the societies, not the LPC. Both Polokwane and Gauteng, I did not ask them. That I was responding to that.
Chief Justice, I'm no clearer with that response. I am no clearer.
I think for present purposes, we can let the matter end here. Then we can debate any lingering questions during deliberations. Fortunately, we have the experts in this area.
Chief Justice, just one point. I think for the record, we must say that it is important to get a letter of good standing from your bar as well as from the LPC, because there might be a letter of complaint against you at the bar that is not at the LPC.
I'm sorry?
Most advocates give us letters of good standing both from the bar and from the LPC. And I think there is a good reason for that.
Well, is that a question?
No, it's a comment for the record that I think it's important for candidates to. The LPC is the statutory body, but the bars are there for a reason. And often complaints are lodged with the bar that don't get to the LPC, and we need to know about them.
Chief Justice?
Commissioner Pillay first.
Thank you, Chief Justice. Advocate Ledwaba, may I ask you about the matter of Shabalala versus Maluleke and others?
Chief Justice, I apologize. I wanted to follow up on this issue before a new issue.
No, I thought hers was a follow-up. I learned only now that it's not.
Yes.
Ask your follow-up.
No, thank you very much, Chief Justice. I think we need to clarify something. LPC is the sole regulator of all the legal practitioners in South Africa, and that is a fact. The voluntary associations, they are exactly that. It might be recommended that if you are associated either to the GCB, PABASA, or LSSA, or any of those are voluntary associations. If you do get anything from them, then that's fine. Perhaps it can be recommended. But I don't think it is proper to say, as a matter of course, for these proceedings, we need to get letters of good standing from those things. I don't think that is proper. Thank you very much, CJ.
Well, as I said earlier, I think that's something we can debate later during deliberations and our own housekeeping sessions. Not as far as it's concerned for the candidate. He's given his best answers and we can't take the matter any further with them.
I accept that.
Thank you.
Sorry, Chief Justice, but when a statement of law is made which is incorrect, I don't think the JSC can responsibly leave it. There is a judgment of the SCA by Judge Ponan in the entire matter that says the bar is the custodian of good morals of advocates. So that's the point that Commissioner Steinberg is making.
And my only point is that for purposes of this, what is happening here now with that candidate, I think we may have exhausted the topic. This other discussion we can have among ourselves later. Or do you disagree with me?
I accept that, CJ, but I think the position is wrong nonetheless, that Advocate Ngwatobi is addressing. Thank you.
Thank you. Minister?
Thank you very much, Chief Justice. Good morning, Commissioners, and good morning, Advocate Ledwaba. How are you?
Good morning, I'm okay. I'm okay, Minister.
Okay. I'm okay. I want to focus on the Amalgamated Lawyers Association complaint.
Yes.
I'm sure you are aware of it.
Yes, I'm aware of it, yes.
Firstly, I just want to know, they say you failed or refused or neglected to allocate a hearing date beyond their request.
With respect, Chief Justice. Chief Justice?
Yes.
With the greatest respect, in relation to the question put in relation to this matter. Perhaps I thought it is important to alert the honorable commissioners and the commissioner minister that the dispute or the complaint raised by Amalgamated Lawyers Association against the candidate is a matter is a subject of appeal pending in Toyando local division. The date is set for the 6th of December 2024 to be heard by the full court in that local division. So I just thought I needed to alert the minister that the matter is sub judice, arising from the same complaint and the proceedings.
All right. Thank you. Thank you, JP.
I can let it pass on that note. I think it will help.
All
Thank
right.
you.
Thank you, Minister. Commissioner Moimang?
Thank you, CJ. Good morning to yourself and commissioners. Good morning, Advocate.
Good morning, Commissioner.
Just one from myself about the comment made by GCB. In as much as they acknowledge your experience, their view is that your appointment would not further the diversity of the bench.
Yes.
So I just want to get a sense from yourself, what is your view in relation to that statement? Thank you.
Well, yes, that question was raised last year, but this year, in May, I had a discussion with the Deputy Judge President, and she asked me if I'm going to make myself available this year. I said yes. If nominated, I say yes. And she said to me, in any event, that issue of a female judge in Tando local division has been resolved, because she said to me, she's permanently based there in Thohoyandou. And I haven't seen her in Polokwane from term starting after March. So I thought, from what she said to me, because she's now there in Thohoyandou, we've got her as a woman, we've got 2 judges. That has been addressed. But that doesn't mean that if I had not had a discussion with her, and I was asked to make myself available, I'll not make available. But I'm just saying that question, from what she told me, that has been resolved.
Thank you, Advocate Laba. Thank you, CJ.
Thank you, Commissioner. Another one? Okay. Is there follow-up? Okay. JP Mlambo.
Good morning, Advocate Ledwaba.
Good morning. Good morning, Commissioner.
Just to confirm this, you say you've done something like more than 68 weeks acting.
Yes.
And in that time, you've done predominantly civil work.
Yes.
Right.
Yes.
Have you ever heard of the plus connivence rule, and in what circumstances is it applied?
Well, yes, plus connivence rule is a rule that used in disputed litigations. The background is this: as a litigant, when you approach the court on motion, you decide whether you decide whether you want to go for trial or you want to go for application. And trials that where evidence are given. Now, that rule works in this way. If you are a litigant and you decide that you want to follow the application route, well knowing that potentially there can be dispute of facts, you denying parties an opportunity to be tested on evidence. And the rule is this: once you have decided to make that decision, and evidence are given, and there's a conflict, there's a dispute, you must accept that the evidence that's come from the defendant will not be rejected unless it's so far-fetched that it can be rejected on papers. So because you did not give, you chose a route that denies the defendant an opportunity to be tested, you cannot complain if his evidence is accepted, unless it's so far-fetched that it should be decided, it should be rejected on paper. That's how I can summarize it.
Okay. One last question, CJ. In your questionnaire, am I correct that you list, is it 2 or 1 of your judgments that were upset by the SCA? All the others were upheld.
Yeah, it's only one, the Mukuba judgment that was upset by the SCA.
Thank you very much, CJ.
Commissioner Pillay?
Thank you, CJ. Advocate Lidwaba, the minister had asked you about the complaint from ALA.
Yes.
And I think the indication from the JP was that there's a matter pending before a full court that deals with some aspect of the complaint.
Yes.
Is that matter the Shabalala matter?
You're asking me about that matter that's in there?
Yes.
No, I'm not aware of that matter, December. That's the judge president's talking about it.
Yeah, but you dealt with the Shabalala matter at some point.
Yes.
In relation to an allocation of that matter on the urgent role.
No, I was never approached to allocate the date. I think what the judge president was saying that matter as a whole, if I understood him correctly, it's before the full court.
Yes. I just want to deal with the question of allocating that matter. It had come to you when you were in the urgent court, and you wanted to allocate it as a special motion.
No. I didn't do that. What happened was that I decided that the council could not appear. That litigant was left without a legal representative. So we had to give an opportunity. And there was a suggestion from one council to say, can we approach a court for special allocation? I said, and it's on record, and I said, that is done by the judge president. It's not done by me sitting in a sitting court. So the directive says if you want a special allocation, as parties, you must direct letters to the office of the judge president to be allocated that. So we're dealing with that. But at that point, in that matter, we got a date from the registrar. That matter was allocated again on urgent basis to a date. And I'd left by then. I'd left Toyando then.
But you'll know that the issue raised by ALA relates to the information you had imparted to the parties. You said to them that Judges Patudi, not the JP, the other AM Patudi, and Judge Chidada had indicated that they were conflicted and therefore not available to preside over the matter.
Yes, the issue was this. It's Judge Patudi, who was the senior judge, who indicated to me that both of them are conflicted.
Yes.
That's the first answer.
Okay. You know that Judge Patudi has issued a formal ruling dealing with the matter?
After I've left, yes.
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 And in his formal ruling, he indicates that that exchange never happened, that exchange between you and him.
No. Okay, let's deal it. There are two issues there. The first issue is that when he gave me the file, we had a discussion. But then when we were talking about allocation of judges, and I indicate to them, the allocation, as far as I remember, the allocation for special dates are done by the JP. But I don't know if the senior judge sitting here can do that. Then we adjourned. When we adjourned, I looked at the directive confirmed that only the judge president could do that. So I did not go to him and say to him, do you have authority to allocate the special trial? Because special trial, then I confirmed from the directive that that was done by the JP. So what I did, I postponed this matter to still a urgent court. It was for the parties, if they wanted to get this matter to special allocation, to approach the Judge President's office by way of writing.
So
That's
when
what I
Judge,
explained.
so when Judge Patudi records in his ruling, and I'm just going to read to you what he records in his ruling, right? He says, at this stage, I find it apposite to indicate that on the said date, Lidwaba AJ did not present himself to me in chambers as the senior judge regarding this matter, or at all.
Yes.
It is accordingly a patent error, as placed on record, that Lidwaba AJ approached me in chambers, ostensibly seeking advice on whether or not to postpone the matter. So,
Yes.
so you agree with that?
I agree with him that I never approached him for special allocation. That I agree with him. Because the directive, as I said, when I checked, the directive does not give a senior judge authority to give a special allocation. So I did not go to him, he's right.
But when you reported to the parties that Judges Patudi and Chidada had indicated that they were conflicted, not that they were not available, that they were conflicted in this matter, where did you get that information from?
Okay, let's deal with one part. Let's park this thing of saying, if we agree that the recording that are set to the parties, I think the person who give the special allocation is only JP. I'll check with the senior judge if here in division can do that. Then I checked and I found that okay, he can't do that, and then we went to the registrar. But there are two instances where the Patudi talks about. The first time, when this matter was allocated to me, it was allocated to him in his chambers. He gave to me this matter in his chambers. I went with him. I only went to his chambers once. Then I did not go to him, to his chambers again. He's right, for special allocation.
Advocate Lidwaba, my question is, when you said to the parties, when you recorded that both judges had indicated that they were conflicted, where did you get that? Where did you get that information from?
No. I said on the record. I confirmed on the record that Judge Chidada was involved in this matter. There's a ruling that was made. That came from our meeting with Judge Patudi when he said to them, they were both conflicted. But there's nothing in the files that says to me Judge Patudi himself may have been conflicted. So it comes from the record that yes, Judge was involved in this matter at one point where he made either a ruling or a judgment. I don't know. I can't recall now. But that is it. So Judge Chidada, I never had a meeting with Judge Chidada. No.
You see, Advocate Lidwaba, there's a transcript of what you said.
Yes.
And I'm going to read the first two lines of the transcript.
Yes.
The transcript is only one of them, so they indicated to me that both of them are conflicted. I think they indistinct about this matter, so I'm going to adjust this matter to the 16th of April.
Yes.
So those are the words you said, that both of them are conflicted. You put it on the record.
Both of them are conflicted. No, I never
You said only one of them, so they indicated
Yes.
to me, that both of them, they are conflicted.
No. Yes. That I hear what you say, but I never met with Chidada to say to confirm from him that he was conflicted. I got it from the record.
But let me just take it slowly, Advocate Lidwaba. Do you accept that you made these utterances?
To say both of them told me. No, I never said.
No, you said, so they indicated to me that both of them, they are conflicted.
Yeah, no. If that is that will be incorrect because I never met Chidada in this matter. Then even now, I met Judge Patudi, but from the record, Judge Chidada was involved in this matter. So for me, I confirm that he was conflicted. Yes.
Chief Justice, sorry, Advocate Lidwaba.
Yeah.
Did Judge A.M.L. Patudi tell you that he was conflicted or not?
He told me that he was conflicted. He told me in his chamber, he said himself, we were three. Yes. And I was not I was on criminal matter. I was doing criminal matters. When he called me in the office, he said, text is fine because both myself and Chitata were conflicted in this matter.
Yes, so when on the 16th of April 2024, he said, in a judgment,
Yes.
it is manifestly and wholly untrue and incorrect that I had any conflict of interest in the matter. He was lying.
Well, I don't know. It's a senior to me. I won't say it's lying or not. But I can only tell you about what he told me in chambers. But whether it's lying or not, I won't be able to say that.
Can I just follow up, Chief Justice?
Yeah, before you do that, Commissioner Pillay, you say, what does the fact that he's senior to you have anything to do with anything?
Yeah, well,
You were asked if he lied in that judgment, and you then in your answer you include that he's senior to you, and that just confuses me. Why is that relevant?
Yeah, it's relevant to me because in my response, I said we were sitting there, we were three of us. So he was the senior judge of all of us. So when he called me, he said to me, I'm allocating this matter. He was allocating this matter to him as a senior judge in that division. And it's explained to me that himself and Chitata were conflicted in that matter. So it's in that context that I said I was given a matter by a senior judge who explained to me he's conflicted together with his judge.
Commissioner Pillay?
Thank you, Chief Justice. Advocate Ledwaba, I want to give you the benefit of my concerns so that I could get your response to it.
Yeah.
Just a few minutes ago, I put to you exactly what Judge Patudi said in his ruling, his formal ruling.
Yeah.
And I asked you, do you confirm that it's correct? And your answer was that you confirm that it's correct.
Well, maybe just remind me the ruling. But if the ruling says, I never went to his chambers where I got the file, no, that will not be correct. Because I got the file from his chamber.
Then I must ask Advocate Ledwaba, why did you confirm it when I put it to you just now? Because he says that Ledwaba AJ did not present himself to me in chambers as the senior judge regarding this matter or at all. And I put that to you and you confirmed that he's correct.
Commissioner, let's distinguish two instances. The first instance is when I received this file. I went to his chambers because he called me. The second instance is talking about when I indicate to the parties that I will inquire from the senior judge if he has authority to to allocate special trials. And he's right when he says, I did not come to his chambers. Because when I look at the directives, I confirm that only the JP can allocate special trials. And those special trials are allocated on the basis of parties applying to the JP. So there was no need, even if I indicate to the parties, I'll inquire from the senior judge, meaning Patudi. But I did not go there, because from the directive was clear that only JP allocates special trials. So it's right, I didn't go to his, but I went to his chambers when I received the file.
CJ, just one small follow-up from this. The JP is here. Mine is, the candidate is saying he was allocated a matter by a senior judge in the senior judge's chambers. JP, for the record, do judges allocate matters to themselves in Toyando, or how does the process work?
As far as my knowledge can stretch, matters are often allocated to judges by a senior judge.
Often, you said. Often, did you say often?
Yes, I said.
Not as a matter of course.
Well, I want to accept as a matter of course. It is a senior judge who would often allocate matters to a judge.
Yes, Jay. Or was that all? Oh, all right. We've reached the end of your interview, Advocate Litobo. Is there anything you wish to raise with us before you leave?
No, there's nothing. Well, I can only check that if there's still a need for me to get the letter from the complainant to the LPC to say that she's withdrawing the matter, then I'll get that letter. But I'll get an indication if that's the Senate, then I can do that. I can get it from here.
All right. If we determine that it's necessary, the Secretariat will be in touch with you and let you know.
Okay, all right.
Thank you very much, Your Excellency.
Thank you.
Good
My mic
morning,
is
Chief
off.
Justice.
How are you?
I'm fine, Chief Justice, under the circumstances.
All right. You are a regional magistrate.
Yes.
Where are you stationed?
I'm stationed in Mankweng, but I'm currently in Polokwane.
Where your foray into the legal field started with you obtaining a BProc degree. From which university was that?
University of Limpopo.
And then you did an LLB.
Yes, Chief
and
Justice.
With success. Where did you obtain the second degree?
Same university, Chief Justice.
And then you did an LLM.
Yes.
Same university.
Yes.
You started out as a prosecutor in 1995.
Yes, Chief Justice.
And you remained in the NPA until 2003
Yes.
and became a magistrate.
Yes, I became a magistrate in 2003.
Then in 2016, you were promoted to regional magistrate.
Yes, Chief Justice.
So how long have you been in the magistracy? For 20?
It's more than 20
1
years, Chief Justice.
Yeah. And have you had an opportunity to do civil work either in the district court or in the regional court?
In fact, the reason why I'm now stationed in Polokwane, Chief Justice, is because I'm now dealing strictly with civil cases since 2018, July 2018 to present.
All right. When did you start acting as a judge?
I started on the 7th of August 2023.
And for how long have you acted?
When I count the weeks, it's 14 weeks, Chief Justice.
And what kind of work did you do in these 14 weeks?
I did criminal work, I did civil work as well.
What kind of civil work? Civil cases?
RAF matters and all kind of civil work that was there. In fact, when I started, my first 3 weeks, I was in the motion court in 2023. So I did the motion court for the whole 3 weeks. That is opposed, unopposed, agents as well.
Did you sit in the civil trial court?
Only in rough matters.
All right. And did you get to do civil appeals?
Yes, I did.
Did you get to write judgments?
Yes, I did, Chief Justice.
About how many?
I've got 14, no, I beg your pardon, I've got 20, I've got 22 judgments, and 8 of these judgments, it's criminal judgments, and then the rest is civil judgments.
Any of them reported?
No.
Okay. You've done other things outside the judicial seat. You've written an article.
Yes, Chief Justice.
In labor law, interestingly.
Yes.
That was published. Where did this interest come from, and why have you not written again?
The issue of precautionary suspension that I wrote about, it's something that a family member was suspended for a period of about a year, without a charge sheet, without a disciplinary inquiry. And I then had an interest in wanting to know more about precautionary suspensions based on that.
Yeah, that's good motivation. You are also involved with mediation programs and have done some work there. Can you just tell us a bit about this project?
In 2012, I went to the USA, specifically in California, UC Hastings University. And when I was there was something that drew my interest, and that is the fact that the students of that university, those that were studying ADR, that is Alternative Dispute Resolution, were given an opportunity in courts to do mediation. So when I came back, I then spoke to the head of the court, I spoke to the chief magistrate, I spoke to the University of Limpopo, and I made this proposal to them. And fortunately, they acceded to the proposal. And what I did, I then arranged that final year students of the University of Limpopo that were studying alternative dispute resolution could get an opportunity to come to the court, the Mankweng Magistrates Court, because at that time, I was still at the Mankweng Magistrates Court. So they would get an opportunity to come and mediate in real cases, in the small claims court cases, and I had to supervise all that process.
All right. And you assist with judicial skills training to a variety of interested parties called attorneys, advocates, prosecutors, and district magistrates who aspire to become regional magistrates.
I do that, Chief Justice.
All right. All right, I'm going to hand over to Judge President Patudi to put questions to you, if he has any, that is. JB?
Yes, thank you very much, Chief Justice, for the opportunity to put questions to the candidate. Greetings to you.
Good
Madam
morning.
Goveni.
Good morning, JP.
Thank you. Let us talk about your experience on the bench as a magistrate, district magistrate, as well as later as a regional court magistrate. Would I be correct that in your cumulative period of 23 years of court experience as a magistrate and regional court magistrate, you've been exposed to both the civil law, as the Chief Justice has already alluded or probed into, criminal law, and procedure, and the law of evidence when adjudicating on a variety of cases. Am I right?
That is correct, JP.
Now, the 23 years of judicial track record enhance your ability to run a courtroom?
That is correct, JP.
And did you experience any material difference as to the procedure, especially criminal procedure, as well as how to adduce, rather to collate evidence that obtains in the lower court as well as in the high court where you've acted? Did you note any material difference?
I beg your pardon, JP.
Yes.
In the regional court especially, we do cases that the High Court has jurisdiction over. That is in the criminal matters.
And that would be your example, your murder cases?
Murder cases,
your
rape cases,
your
yes,
robbery with aggravating circumstances?
Yes, we apply the provisions of the Criminal Law Amendment Act 105 of 1997. That is what is commonly referred to as the minimum sentences. So we do that in the regional court, we do that in the High Court. So as such, I don't have a problem in dealing with criminal cases in the High Court because I deal with them, the same cases in the regional court. Not that I have a problem with dealing with civil cases. That is the case as well.
Yes, and the law of evidence is the same. The rules of evidence are the same. There's no difference.
Yes, JP.
Okay. Now, with that kind of knowledge, it has rooted itself in a period of 23 years.
Yes, JP.
Right. Now, you mentioned at page 15, paragraph 813 of the questionnaire.
15.
That, yeah. That is, that from the period 2003, before your appointment as a magistrate for Mankweng district, you were also appointed as a magistrate for Giyani district.
That is correct,
Which is
JP.
not far from the Thohoyandou area, am I right?
Yes, JP.
So, can one say that you're quite familiar with the demographics of the Thohoyandou area?
In fact, JP, I'm married in that area for over 20 years, so I know the demographics of that area.
Yes. And of course, in your you've mentioned that you've now have 14 weeks credit, acting credit. No longer 9 as it appears there, because that was at the time when you submitted or completed the questionnaire.
That is correct, JP.
So all in all, you say it's about 14 weeks of acting stint
Yes.
in Limpopo
Yes,
division. And that you presided therefore over a fair number of criminal cases, that is criminal trials,
That is correct.
at high court level,
That is correct, JP.
and also in civil trials, including both criminal and civil appeals.
That is correct, JP.
And in doing so, you also had occasion to write on behalf of the full court judgment in the Muneri case, for example.
Yes,
Do
JP.
you like to share us just briefly the succinct principles you've identified in that court, in that judgment?
JP, in that judgment, there was a serious dispute of facts. And because of the fact that there was a serious dispute of facts, one would have expected that the Korakuo should have either dismissed the application, or if not dismissing the application, then the Korakuo should have ordered that at least oral evidence be laid before it, or refer the matter for trial. And that is precisely what the Court of Appeal did, the full court.
Yes. Now, you presently reside in Polokwane?
Yes, JP.
If considered for appointment, would you be ready to or willing to relocate to Thohoyandou?
Yes, JP, as I've already said that I'm married in that area. I think my husband will actually be happy that we will then go back home.
That court in Thohoyandou had, before the advent of democracy in 1994, being established along the old separate development policies. In other words, it was an independent court in an independent state, then called Venda. And its establishment has always just been 3 posts at a time. And since 1979, do you know whether there has been any female judge appointed for that court up to today, which is 2024?
I
Or
know that
is
currently...
that is to your knowledge.
I beg your pardon, JP.
Yes,
for,
no
for
problem.
interjecting.
Yes. your answer?
Thank you.
Do you know whether, has there been any female judge there?
To my knowledge, not JP, because even currently, I know that there are two sitting judges, male sitting judges, currently.
And I'm just saying that, so if appointed, you will be the first in the history of that court, female judge.
That is correct, JP.
All right, any of your judgments that you've produced in this short space of time, especially the civil ones, anyone that has been overturned by the Supreme Court of Appeal?
To be honest, JP, none of them were taken on appeal, as far as I know, because I take it that before it could go on appeal, I would be notified, because the leave to appeal will definitely be brought before me.
Yes. So
one of them that I produced, I got a notice. In fact, I got a request for a date for the parties to bring an application for leave to appeal. But on that date, instead of them appearing, the matter was then removed. And that is as far as I know with regard to appeals. So in other words, there is not any case that I know that was taken on appeal.
And as to reserved judgments, do you know of any reserved judgment which has been outstanding over, well over 3 months period?
I don't have reserved judgments, JP.
Yes. Thank you, Chief Justice. I have no further questions.
Thank you, Judge President Pachudi. Premier Ramatuba, do you have questions for this candidate?
Chief Justice, and good morning to Commissioner, and morning, I advocate Gobeni. I just want to make a follow-up on what the President has just asked. Advocate, according to you, as you were responding to JP, for the past 45 years, the Toyalo has never had a female judge, and which is a confirmation that we still have serious challenges when it comes to transformation within the judiciary. This is also evident by the fact that it's only after 30 years of our democracy that even the Chief Justice now will be a capable woman. My question to you is that, as a woman who has made it this far within the very same system that is very difficult to transform, what is it that we have done in your current position as a magistrate in terms of mentoring and uplifting fellow women within the judiciary? And what is it that you are going to do once you are affirmed or recommended and appointed as the judge of that a court which has never had a female for 45 years? And I just really want to understand because today marks 85 years since Charlotte has departed. And one of the issues that her teachings in her famous quote is about as when she talks about the work we do is not about ourselves. She further indicated that as you rise, you must take along another girl child with you. So as a girl child who grew in the rural dusty streets, what is it that you have done and what is it that you still are going to do to make sure there's transformation within the judiciary? Thank you, Chief Justice.
Thank you, Commissioner. Thank you, Premier. If you look at my questionnaire, you'll see that in February 2024 to March 2024, I was involved in training. And this training was specifically for people, and there were a lot of women in that training. And that is people that are aspiring, lawyers that are aspiring to become regional magistrates. And I'm very passionate in that, because if you look at my questionnaire, you'll see that that was not the only time that I participated in this kind of program where we train women who are interested or aspiring to be regional magistrates. So I'm making that difference as a woman. And even UNISA students, we take along UNISA students. I remember that in this year, I had UNISA students come into my court to come and observe as to what is happening in a courtroom, because most of these people, especially the UNISA students, do not have that practical knowledge of what is actually happening in court, because of the fact that theirs is a distant learning. But there were women that came who I allowed and mentored them with regard to court proceedings. And I've already mentioned the fact that February and March this year, I was involved in such a program. Thank you.
Was that your only question, Premier?
Yes, that was my only question.
Thank you. Marumahai?
Thank you very much, CJ. Good morning, Magistrate.
Good morning, Professor Marumahai.
I have two questions for you. The first one comes from what you stated earlier on the judgment that leave to appeal was refused by a single judge, then leave was granted by the Supreme Court of Appeal to the full bench that you spoke about earlier on.
Yes.
And you gave two options, that it's either the matter is dismissed when you use the word serious disputes of fact, or the matter can be referred to oral hearing. Obviously, there must be a basis why the matter will be referred to oral hearing. But let's say that option is not there. What will then lead to the court dismissing the matter where there is a material dispute of fact which cannot be resolved on the papers? What will be the basis? Which rule will the court actually use to dismiss the matter, or will the court just dismiss the matter without applying a particular criterion or rule?
That is Rule 6, 5G, and that decision is based on the Plascon events rule that if there is a dispute of fact in an application on affidavits, and the version of the applicant and the version of the respondent are so far-fetched that they cannot be reconciled, then that application can be dismissed on that basis, because as an applicant, the applicant is the one that has to prove its case before a court of law.
Yes. No, thank you very much. The second question that I have for you is, I want us to deal with Rule 23.
Sorry, CJ. I want to follow up on the first answer.
Commissioner Nungonyane.
Thank you. Good morning, Madam.
Good morning, Commissioner Nungonyane.
Yes. Just a follow up on the answer to the first question, that where there is a dispute of fact, you simply dismiss it. Did I hear you? That if there are any material dispute of fact, you simply dismiss that application. I hear you.
You can dismiss, or you can refer the disputed facts for oral evidence, or you can refer the matter to trial.
Thank you, CJ.
Any other questions for the candidate, colleagues?
No, colleague.
Or there's a follow-up? Is there follow-up, Prof?
Sorry, CJ, I have the second question that I had to ask.
Oh,
Well,
I'm
there
sorry.
was a follow-up.
Okay,
No,
go ahead and
I
answer,
apologize
ask
for
your
that.
question.
I want us to talk about Rule 23. You don't have to worry about the number of the rule. It deals with an exception. The exception is generally referred to as one of those procedures that can assist the parties to be economical in their proceedings by actually ending the proceedings quite earlier. I just want to understand under what circumstances because both parties can raise an exception for different reasons, under what circumstances can the defendant raise an exception towards what is pleaded in the particulars of claim? And what will be sort of the test that will motivate you as a judge to exercise your discretion to be able to uphold the exception?
The exception that is usually raised is the fact that the particulars of claim are vague and embarrassing. So that is mainly the exception that is normally raised by the defendant. It should be the defendant because the defendant will then be taking exception to the particulars of claim. But the experience that I have is that they would normally raise an exception that the particulars of claim are vague and embarrassing, and as such, they are unable to plead.
No, well, yes, that is a normal sort of claim that they will make. But what I'm trying to get at is what will then, what justifies that vague and embarrassment that they are talking about? Because anyone can stand up and say, but this pleading is vague and embarrassing for whatever reason. But what will then you, as a presiding officer, make a call that indeed it is vague and embarrassing? Like what is the meat behind it?
Let me not guess on that answer.
No, that's fine. Thank you very much, CJ.
Thank you, Prof. Commissioner Nkaito.
Ms. Gobeni, good morning.
Good morning, Commissioner Nkaito.
Yes, now I've read the two judgments. They are comprehensive and well written, especially the appeal judgments. And you, in fact, had a better comprehension of the Plascon-Evans test in your judgment than in your answers here. So I suppose, sometimes the pressure of being interviewed, interferes with your sort of intellectual output.
That is correct.
Is that correct?
Yes, that is correct.
All right. No, that's fine. No problem. I just want to ask you on a different subject, on an academic subject. You published the article on precautionary suspension in 2013. And I don't know if you've followed up on the legal developments, because there's now a recent judgment called South African Breweries versus Long by the Constitutional Court, which says that it is not unfair not to hear, because in your article I understood you advocated for a hearing at precautionary suspension stage. Now there is no right to a hearing at precautionary suspension stage according to the Constitutional Court. Is that judgment correct?
I would caution
Commissioner,
you to be very careful as you
Commissioner,
answer
who
that
am
question.
Who am I to say that the Constitutional Court is wrong?
No, that's fine. You don't have to answer. I understand your predicament.
Commissioner Steinberg.
Good morning. First, just to salute you for the journey that you've been on. Your judgments are excellent. Your articles are excellent. So the question I ask in no way goes to ability, it goes to experience. The review from the GCB is concerned about your experience in civil law. You clearly have a very strong grasp of procedure and evidence. I just want to ask you, have you had much experience in public law?
I beg your pardon, Commissioner?
Have you had much experience in public law?
Public law?
Yes.
Maybe I don't understand the question well, Commissioner.
Administrative law?
Not that much experience, but what I can say is that the last judgment that I wrote in the High Court is the judgment that dealt with Rule 53. That is my last judgment that I wrote.
Yes.
Yes.
Let me ask you a question. If you had two applications before you, and one was challenging a tender that the municipality had awarded, and the other was challenging a policy decision of the Premier, how would you approach them, and would they be different approaches at law to those two decisions that are being challenged?
Commissioner, I haven't applied my mind to such a situation, so let me not guess.
Thanks. Thank you.
Commissioner Hassan?
Thank you very much, CJ. I'm on this side here. Advocate, I don't know if you can see me. Yes, hello. I'm just interested, I've seen on the questionnaire that you've done a number of trainings run by Sajay, but I see that quite a few of them are around magistrates. So I'm just interested if you've done any judicial in terms of judges or aspirant judges training programs with Sajay or just generally. Thank you.
Not, Commissioner.
President Mulemer?
Thank you, Chief Justice. Good morning.
Good morning,
Ms.
Commissioner.
How are you?
I'm fine under the circumstances.
Yes. I'm going to ask you a very easy question. Under which circumstances would you grant an order de bonis propriis?
That is if the order that is granted, the bonis propriis, is actually an order that is granted against a legal representative. So there must be something that the legal representative would have done that is so gross, or let me say gross, to an extent that the court finds that the legal representative has to bear the costs. Thank you.
Thank you, CJ.
Commissioner Lechonyen?
CJ, thank you so much. Good morning, Regional Magistrate Ngobeni.
Good morning, Commissioner.
CJ, let me declare upfront that my village falls within the jurisdiction of Mankweng, and that I have no ties with the Regional Magistrate. Regional Magistrate, you have spoken about mediation here. I want to check with you, if mediation was to be an option in a province like us where we have traditional leadership disputes which generates tensions in our communities, what will be the benefits of mediation if we apply it to, or as an approach to resolution of traditional leadership disputes?
Thank you, Commissioner Lekganyane. The main purpose of mediation is restoration of relationships, that is restorative justice. And the other advantage of mediation is that costs are saved, because if the relationships between the people, especially I'll just say the villagers, if there is the relationship between the villagers is restored, there won't be any need for that villager who is aggrieved to take the matter to court, spend money on legal representatives, because the matter would have been resolved. Thank you.
Thank you so much. Thank you, CJ.
Commissioner Baloyi?
Good morning, Regional Magistrate.
Good
morning. Yes.
Good morning,
let me do what Commissioner Lekganyane did. Your maiden name is Baloyi. Let me declare there's no relation there.
That is correct.
I'm just following on the question or what you were asked by Commissioner Steinbeck and your response. Is it fair to say that in your magistracy role and functions, you may not have come across matters that fall within public law?
That is correct, Commissioner.
And in the times that you have acted in the High Court, when you have been confronted with questions that have never arisen in your magistracy role, how have you gone about to inform yourself and to find answers to them?
Commissioner, fortunately, one has the advantage of always referring either to case law or referring to you know, there is a lot of research that one can do to keep herself abreast of what is happening in the law. As I've just said that my last judgment was a judgment on Rule 53. So I had to read so that I could understand as to what that application involves. Thank you.
Thank you, Chief Justice.
Follow up, CJ. If I may follow up, Magistrate, in the Magistrate Court, haven't you done criminal law?
I did a lot of criminal work.
Is that not public law? Surely you may not have been exposed to other areas of public law. So as any other person who can come may not be exposed to other areas of commercial law, but you have been exposed to public law.
I agree.
Yes,
I agree,
thank you very much,
Commissioner.
CJ.
Judge President Mlambo, is this the
Can I
follow-up, Prof?
Follow-up.
Commissioner Steinbeck, yes.
I just wanted to say, Regional Magistrate, that I'm entirely satisfied by your answer to Commissioner Beloy, that you clearly, when you get a new issue, one can see from your judgments and your writing, you know what to do. So having asked the question, I just want to say that I'm entirely satisfied with your answer, would have full confidence in you coming to appear before you on a question of administrative law.
Thank you.
Judge President Mlambo.
Thank you very much, Chief Justice. Good morning, Regional Magistrate Ngobeni.
Good morning, JP.
You know, the Tohoyando court is a real poser, if I may say so. When it still fell under Gauteng, I remember being the responsible JP when I had a stakeholder engagement there. The female practitioners asked to see me on their own. And the sole issue was to challenge me and those who came before me of never ever sending women judges to Tohoyando. Were you in that group?
Not Commissioner.
So you don't practice there?
No, I don't, JP.
Yeah. I must say it was an eye-opener because I don't know why we get into these stereotypes, but it opened my eyes, and that's when we started sending women there. I just want to understand your answer when you said, I don't know whether I understood you correctly, that you say your exposure as a magistrate or as a regional court magistrate is sufficient for you to be appointed as a High Court judge?
That is what I'm saying, JP. Thank you.
I thought you qualified your answer that only in criminal law, but not in civil law. Or are you saying also in civil law?
Also in civil law, JP, because as I said, since 2018 to present, I've been moved from Mankweng to Polokwane because I'm dealing specifically with civil law.
But as a follow-up, the regional court does not deal with civil work that goes to the High Court. that is done by the High Court in the same way as the criminal work. So how does your exposure in civil law in the regional court prepare you sufficiently to be appointed as a High Court judge?
Thank you, JP. We do divorces. We do cases dealing with state liability. We do all cases which can actually come to the High Court as well. And maybe just to inform the Commission that I've written judgments as well in the regional court. And when I counted, before I came to the interview, I counted 98 judgments.
But you do confirm that the High Court has appellate jurisdiction over your judgments in the regional court?
I do, JP.
I see. One last question, CJ. You've had 14 weeks in the High Court. And in your questionnaire, you say your overall experience is 60% criminal. I want you to comment to the comment by the GCB that says your appointment will send a message that experience in High Court litigation is not necessary to be appointed to the High Court.
My response to that question, JP, will be, am I unable to do the job in the High Court? Surely not. And that is based on the judgments that I've written. So even if my experience in the High Court is not that much, but given the job, I'm able to deliver. Thank you.
Thank you, CJ.
Just a follow-up on that. Ms. Ngobeni, have you attended any courses, for example, courses that are offered by SAJE or courses that are offered at your division to train aspirant judges or acting judges?
I don't hear you well.
Have you attended any courses, for example, aspirant judges courses offered by SAJE? Sometimes courses are offered within the division, courses that are aimed to train aspirant judges.
Not, Commissioner.
Oh, thank you.
Thank you, President. Did you say you counted that you've written 98 judgments as a regional magistrate?
Yes, as a regional magistrate, yes.
That's quite commendable. It's highly unusual to hear that magistrates generally do not write judgments. I'd love to see some of those. Were they on criminal and civil matters?
This 98 is just civil, Chief Justice.
Just civil?
Just civil.
All right. No, thank you, Regional Magistrate. We don't have any more questions for you. Unless there's something you'd like to ask us, or raise with us.
No, CJ. I just want to thank you for the opportunity.
You want to run away? You're excused. Thank you very much.
Thank you.